When does a criminal justice case typically go to trial? In recent news, many people are asking, when does a criminal justice case typically go to trial? This question has become increasingly relevant as court systems face delays. If you are curious about the timeline of criminal cases, you are not alone. Understanding when a case goes to trial is essential for anyone involved in the legal process. A criminal justice case usually goes to trial after the accused has been formally charged and has entered a plea of not guilty. The timing of a trial can depend on several factors. These include the seriousness of the crime, court backlog, and procedural steps like pretrial motions and hearings. For serious crimes, especially those heard in higher courts, trials can be delayed significantly. For instance, in Scotland, the average wait time between a not guilty plea and trial has increased from 22 weeks before the pandemic to about 43 weeks in 2025. Some cases may even take up to 2 years to reach trial. The process typically begins with an initial arrest, followed by charging the accused. Next, there is an arraignment where the plea is entered. After that, pretrial proceedings occur to resolve evidentiary and procedural issues. Finally, the trial is scheduled. Many cases do not go to trial because they are resolved through plea agreements or dismissed earlier. However, if the accused maintains a not guilty plea and the case is not resolved through other means, it proceeds to trial. Backlogs in courts, limited availability of judges and defense attorneys, and efforts to manage cases digitally can all affect when a case goes to trial. In some jurisdictions, reforms are underway to reduce delays. However, serious felony cases often face longer waits due to their complexity and resource constraints. In summary, a criminal case typically goes to trial after the accused pleads not guilty and pretrial procedures are completed. The timeline varies widely based on the court system's capacity and the nature of the charges.